I omitted the beer.
Hold it. You know what, sir? Don't play fast and loose.
I got
The
it.
story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too. That's how stupid your story was.
He is.
Really?
He's
No, he was not being honest. I mispronounce your name every time, sir.
It's okay.
I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today. Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He has indicated that he had O'Doul. So my only question is, does your client wish to stick to that story? Or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed.
That is correct, Your Honor.
And why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Tell me that. So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beer.
Hold it. You know what, sir? Don't play fast and loose.
I got
The
it.
story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour.
No, I didn't have
in
that.
order to reach that level.
Sure.
And could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders.
I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really? No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about it. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol. And he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. And he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he's asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
Mr. Lanto, you're talking crazy. See, that's why you get in trouble, because you like to talk and you think you know it all and you don't listen. I'm going to indicate to the assignment clerk that I want you here in person.
Well, I feel like I'd be in danger if I came there. I'd be in danger.
No, you won't be in any danger. I'll assign a policeman to watch over you.
That's the
Chris,
scariest
will
thing
you
I
watch
could
over
ever hear.
him when he comes?
Absolutely.
That is the scariest thing I could ever hear.
Mr. Lanto, can you hear me?
I can hear you.
Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
I wasn't, that's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to get discovery. It's not the
Well, the first thing I
prosecutor.
want. Okay,
You
the
want a
first thing I'd
trial
request-
today? You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere. I was asking for the same thing up in the Clarkston courthouse, and they send me to the Oakland County Jail.
Mr.
to go look
Lanto,
for it.
Mr. Lanto, I'm not gonna produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce to convict. So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial today?
Well, let's see what the discovery evidence has to say. But first, if they could, very first thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney, okay? I'm going to adjourn this matter on his motion for 30 days.
Did you
or
just
so.
say? Can you?
I'm
clarify
going to
something
send
for me?
this to
Did
the
you just-
assignment clerk. Mr. Lanto, you're not listening. See, that's why you get in trouble, because you like to talk and you think you know it all and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully
Well,
your attorney will have the discovery that he wants by then, and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
What did he say? No. You're all
It
set.
seems like you were
leave the
getting
meeting.
angry. It seems like you were getting angry.
No, Mr. Lanto, you can leave the meeting. We'll see you in 30 days or so. Clerk will
Well, and
send
I
you a
just
notice.
Well, I just want the record to show I've asked these same questions in several courts, and nobody has said I'm talking crazy.
Oh, yeah.
That's the first time somebody said I've been anything but reasonable in a courtroom.
Huh. That's amazing.
Huh, right.
You're talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Ask your attorney when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And
That's
then
why
number
we're
two.
asking for discovery.
Okay, and then the proof of jurisdiction is going to be in there? I'm asking a simple logical question. It's either yes or no. The proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time, and your attorney will be here in person, and we can talk about it. So when you get that letter,
Well,
can I put on there that he's in person? I'm gonna indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
Well, I feel like
Exactly.
I'd be in danger if I came there. I'd be in danger.
No, you won't be in any danger. I'll assign a policeman to watch over you.
That's the
Chris,
scariest
would
thing I
you
could
watch
ever
over
hear.
him when he comes?
Absolutely.
That is the scariest thing I could ever hear. And that's coming from a very reasonable person.
Okay, we'll see you in person in about 30 days, whatever date the assignment clerk gives you. And you come into court and we'll take care of business, okay?
So what does it mean to take care of business and I got to come in person and you're going to assign a police officer to me and then you said I'm talking crazy?
No, you got it
Did I
reversed.
just recall what was said on the record? Did I just recall that correctly?
You said no, you said it in reverse. I said first that you're talking some crazy talk. Then I said I'm gonna adjourn it for 30 days. And then I said, because you're worried about it, that I'd have an officer watch over you while you're in court. We'll see you in 30 days.